Landlords, do you know the two routes to possession on an assured shorthold tenancy? So, for all tenancies that are let on an assured shorthold tenancy basis, which is the most commonly used tenancy agreement in England, there are two notices that you should be aware of. First, Section 21 notice. Second, Section 8 notice. These are the two notices that you as a landlord should serve on a tenant should you require possession of your property. Section 21 notice is a notice that is used to notify the tenant that you require possession of your property. It is a non-default notice. It is not a notice that is used should the tenant be in breach of tenancy. The most common reasons that a Section 21 may be used is that a landlord is looking to sell the property. A landlord may wish to move back into the property. There are other varieties of reasons why landlords may wish to use a Section 21, but these are the most common. Section 21 has been around since 1989, which is when the Housing Act 1988 came into force. It was a great tool for those in the private rented sector. Prior to 1989 and the Housing Act being born, it was really difficult for landlords to gain possession of their properties. Tenants had succession rights, meaning that tenants could be within properties for years and years and years and pass the rights of that tenancy down to other family members, meaning that tenancies may well outlive landlords. So in 1989, the Section 21 was born, and it was great news for the private rented sector. However, there are many things that you need to know before you serve a Section 21. In order to serve a Section 21 notice compliantly, there are a list of documents that you, as the landlord, need to be able to prove have been given to the tenant prior to the start of tenancy. These documents include a copy of a past gas safety certificate, a valid EPC, the correct version of the How to Rent Guide downloadable from the government website. The deposit must have been protected within 30 days of receipt and the prescribed information provided to the tenant. And should the property be subject to licensing, a licence application must have been made prior to the service of Section 21. With the introduction of the Deregulation Act on the 1st of October 2015 came several rules in relation to the service of Section 21. Firstly, the Section 21 notice for the first time became a prescribed form, meaning that a landlord must not make any changes to the notice and must serve it as it is written and ensure that all sections are completed. Another key change brought about by the Deregulation Act was that about time. The current notice period that landlords need to give tenants is 2 months. Spencer v Taylor removed the need for a Section 21 notice to be served in line with a rental due date. This is now no longer the case, and a Section 21 notice can be issued at any time as long as the first 4 months of the initial fixed term has passed, and that the notice will expire on or after the date at the end of the fixed term. Please note that a Section 21 notice can never be used or expire during a fixed term. A Section 21 notice now has a shelf life. Shelf life is the duration that the Section 21 notice will remain valid in order for you to take action through the courts should the need require. A landlord now has 6 months from the date of service to act on that notice. Acting on the notice, what does that mean? It means that the Section 21 notice has expired and the tenant has failed to move out. A landlord now has to take the next step in this process, which is making an application to the court for a possession hearing and a possession order. If you're finding this information useful, please consider subscribing to our channel, where you'll find other videos around compliance and legislation in the private rented sector. Be sure to stick around to the end of this video where I'll be giving you more information about further free compliance and legislation training at the end of this section. So we've covered when you can serve a Section 21 notice. Now let's look at when you can't. You can't serve a Section 21 notice if an improvement notice has been served on you by the council. You cannot serve a Section 21 notice for 6 months after the work has been completed. This is what the council and the legislation refer to as retaliatory eviction. Please refer to one of my other videos in this library where we talk about repairing obligations under Section 11 of the Landlord and Tenant Act and the Homes for Fitness and Habitation. There will also be difficulties in serving a Section 21 if you have failed to comply with the documentation that is required to be given at the start of tenancy. If you have failed to provide the tenant with a gas certificate, an energy performance certificate, or the how to rent guide, or you haven't made an application for a licence on a licensable property, then prior to serving notice, I recommend that all of these items are served on the tenant before you do so. Deposit registration is also very important when serving Section 21 notice. You must ensure that you have complied with the 30-day period for both registration, issuing of prescribed information, and the deposit scheme's terms and conditions and any leaflets that are applicable. The other notice that landlords can use to gain possession of their property is a Section 8. Section 8 notice has 17 individual grounds for possession that a landlord can cite. Section 8 notice is a notice that can be used during a fixed term. The grounds for possession are separated into mandatory grounds and discretionary grounds. Grounds 1 to 8 being mandatory and 9 to 17 being discretionary. Some grounds have prior notice requirements, some don't. I would encourage you as a landlord to familiarise yourself with the grounds for possession should the need occur that you may need to rely on one of them. But today we're going to talk about the most common used grounds on a Section 8, and that is surrounding rent arrears. Grounds 8, 10 and 11 are all grounds that are in relation to rent arrears. As previously mentioned, ground 8 is a mandatory ground, and therefore, upon a court hearing, if you are able to prove that the tenant is in breach of ground 8, then the judge must award you possession. Ground 10 and 11 are both discretionary grounds. But we encourage you and advise you when making an application to the court for rent arrears that all 3 grounds are used. If you were to attend court on solely a discretionary ground, this means that it will be down to the judge on the day to make a decision as to whether or not he warrants and feels it applicable to award you as the landlord possession of your property. I would always recommend attending court on mandatory grounds and only using discretionary grounds as an additional should the mandatory ground fail. So let's look at grounds 8, 10 and 11. Ground 8 states that the tenant is 2 months in arrears at the date you serve notice. You must allow 14 days to pass after the notice has been deemed served before you are able to make an application to the court. So if your tenant is in 2 months rent arrears and you have served a Section 8 using ground 8, you allow 14 days to pass and the tenant has not paid. An application to court is made after the 14th day should the tenant have still failed to pay. The reason we recommend the discretionary grounds in addition to the mandatory is because ground 8 doesn't just rely on the tenant being in 2 months rent arrears on the date that the notice is served. It also relies upon the tenant being 2 months or more in arrears on the date of the court hearing. So what does this mean? This means that a tenant could, the day before the court hearing, make payment to you of all of the rent that is overdue or some of the rent that is overdue, leaving you with arrears of less than 2 months and the mandatory ground no longer being applicable. You could potentially end up in court and the judge would not be able to give you possession if you have not added the discretionary grounds onto your claim. Grounds 10 and 11 relate to persistently late payments and frequently late payments. So as you can see, using the 3 grounds together will give you the best possible chance of gaining possession when a tenant is in rent arrears on your day in court. Whilst there are not direct restrictions on serving Section 8 notice like there are with serving Section 21, there are some things that I wish for you to consider. Tenants can make counterclaims against landlords for failure to comply with certain pieces of legislation that may have an effect on your claim using Section 8. For example, if you have failed to register a deposit in the given required timescales, being 30 days of receipt, and have not issued the tenant with the relevant documentation, the tenant can make a counterclaim against you for the failure to comply. If then an award is made to the tenant, this can be offset against any rent arrears that is in place within the Section 8. You could therefore find yourself in a position where the tenant is actually no longer in any rent arrears due to the counterclaim against you. Other areas where tenants can counterclaim and be awarded damages is failure to comply with your repairing obligations. Please bear this in mind when serving a Section 8 notice, and make sure that you have consideration, due diligence and notes surrounding any maintenance throughout the tenancy, should the need arise. I hope you found that useful, guys, and thanks for sticking with me till the end. As promised, I would like to invite you to our quarterly webinar, which runs for roughly around 2 hours, that is jam-packed with compliance updates on legislation that can help keep you as a landlord safe. If you would like to continue your learning now, please click here for further videos on compliance and legislation in the private rented sector.